All right, whoever's joining us on the phone with the last four digits of 4840, can you tell me your name, please?
Robert Gray.
Mr. Gray, okay. And Mr. Vernon, are you able to hear me?
I can hear you.
Okay, so we'll go on the record now. This is Gray versus Gray, case number 231152. We have Mr. Gray present by phone today. Mr. Vernon is connected by Zoom video along with his client. This is set for a status conference. I am in receipt of a report from the mediation service indicating that the case is settled. Mr. Vernon?
Your Honor, we had filed, and I was hoping that would be in your file today, a motion to set aside the mediation agreement. It appears that the marital home has a restitution lien on it through the United States Department of Justice. Mr. Gray's.
Mr. Vernon, I don't know if it's your distance from the microphone, but I'm only picking up every other word and it's very, very faint.
Is this right?
That is not helping. Mr. Gray, they're having some technical difficulties, so if you can just remain on the line, please.
Yes, sir. Did you want me to get on the Zoom thing? There was two ways to get on. I could change it if you want to see me or something. I don't know.
No, you're fine.
Okay, all right.
Judge, can you hear me now?
Yeah, that's better. Yeah.
Okay. See, I think it's that same system with the microphone. I'm not sure why. So, Judge, we filed a motion to set aside the mediation agreement. The primary asset of the marriage is the home, and it appears that the home has a restitution lien filed by the United States Department of Justice as a result of Mr. Gray's criminal behavior, and it appears to be as a result of his failure to continue making restitution payments. Obviously, without being informed of that lien, the mediation agreement can't be satisfied. So we're asking, we did file a motion. We're going to be asking the court to set aside the mediation agreement either as a mutual mistake of fact or as fraud. But it can't be, the terms can't be satisfied without the proceeds from the sale. And the restitution lien exceeds the value of the home. So there would be no value to either party, which would obviously be a miscarriage of justice as it appears to Mrs. Gray. So we're going to ask the court to set aside the mediation agreement. And then I guess we'll have to figure out a way to go forward from there. The motion requests basically some time to figure out what the U.S. Department of Justice is going to do with that lien. And because of the delay, we're going to be asking the court to have Mr. Gray pay the mortgage payments as he resides in the home now that this thing is being prolonged. So that's where we stand.
All right, thank you. Mr. Gray, what's your position on this?
Okay, so yes, I was convicted of a crime in October of 2003. I served my time. I got out. I paid restitution for 5 years. I got off probation. The probation officer told me that the company that we owed restitution to would come back and try to get me to make payments. No one ever did. They took my income tax checks every year. My wages have never been garnished, ever, and I've done payroll checks for other companies, everything. So it was a surprise to me that it was on there. So I did contact the U.S. attorney, got a hold of her yesterday, and she told me that she sent me the documents. I sent one to our real estate agent. I sent it to Mr. Vernon today. I sent it to Mrs. Gray yesterday or today. It's pretty clear. There's no reason to delay this. Once the divorce is final and signed by you, that goes to the U.S. attorney. Then Chet, the real estate agent, gets it. He types out his end, and it says how much Mr. Gray will get at the end of the divorce. The U.S. attorney, what she does is she'll release the lien at the time of the title, as long as there's a check made to the U.S. government on the part that I'm getting. So to delay this, it makes no sense, because I talked to her. I have all the documents. I started filling them out yesterday. There's no reason to delay it. Nothing changes. Whatever I get, the government gets. Whatever she's already getting, I made her an offer today. There's no delay. And like the U.S. attorney told me, she says everything has to be final. So like I was asking for 30 days, but that would put money in escrow and that would change the deal. So I said, I'll be out the day of closing. I offered to, in our original agreement, we were gonna sell the Kubota and we were gonna sell the container, but that would throw the deal off. So I offered her today, give her equal value of it each, that she said was fair. So when we go to title company, it's done and it's over with. There's no reason to delay this. The problem is in my hands. It's not in his hands. The lien is on me, and I'm taking care of the lien. I get nothing. She gets everything she wanted. To delay this makes no sense. And I'm not going to agree to pay for the house while this is going on, because it doesn't have to go on. And I can move out of this house in 3 days. I'm taking a position in Traverse City Monday. I have to now because Mrs. Gray wants to keep on badgering me about my company. So I'm selling the company for $1 to my foreman, and I'm signing a non-compete with Foundation System Michigan Monday. So I can't do this anymore. I'm just getting a job for $18 an hour. So the ball's in their court. There's no reason to delay this. There's none. She gets her money.
All right, Mr. Vernon, any response to that?
I mean, those are the same statements he made to me when we spoke earlier today. I'm just not in a position at this point to take him at his word. I need to talk to the Attorney General's office. I need to review those documents. I mean, the document I received from the Attorney General's office through Mr. Gray identifies that he has provided them with information within 30 days. I don't know if he's done those things. I don't know what that information is going to contain. And based on that information, the Department of Justice is going to have to make a decision as to what they will or will not do. I can't encourage Mr. Gray to do anything until we have answers to those questions. That would be malpractice, so I'm not going to do it. The fact that he has identified to the court that he was making new offers to Mrs. Gray this morning, I think makes it clear that the mediation agreement that we have in place is unworkable. So, I mean, the suggestion that this is easy and done is a complete misunderstanding of the situation.
Can I say something, Your Honor?
Sure, go ahead.
I did not change the offer. If you read the original offer and he gives you the offer that I made this morning, the difference is that instead of saying that the storage container and the Kubota will be sold after the divorce and split equally, I was just giving her fair market value now in the divorce, so she don't have to be tied to that, and we can close this thing with the government faster. That's all I did. I didn't change anything. The only thing, I rephrased that. The only thing I did say was that in the other agreement, I was going to start making the house payment May 1st. But I was told she's not doing very well financially, so I said I'd start making the payment April 1st, and then she can make the truck payment and her insurance, because if the divorce is final, I can't insure the truck. It's against the law, and she knows that because she investigated me for that in 2003. So I was just trying to clarify things so we can get this over with. I did not make any deals that weren't beneficial to her. And if anybody says they were, you can look at the black and white. It's very beneficial. I even gave her $2,000 for her suffering over the last 4 days to pay for extra attorney fees. So I think I've been more than fair. If you prolong this, we can go to January 14, 2026, because that's when my debt drops off if you like. I'm free and clear. Whatever you guys want to do, but I can't just sit here and stay here. If I'm going to go to Traverse City, I'll pay my half of the house when I'm not living in it, but why would I pay all of it?
All right, so
I can't
Mr.
live here
Vernon-
because.
Yeah, all right, I think
Go
I
ahead, I'm
got it.
sorry.
I think what you guys need is, Mr. Vernon and Mr. Gray, I think you need to talk this out some more, and, it sounds like there's some room for negotiation here to get this done. So, Mr. Vernon, I don't have your motion, it's not in the file yet. So the court's gonna set this for a status conference, in 30 days. Mr. Vernon, if that is still an issue, we can hear your motion at that time. But I think what should happen is, the two of you should have some discussions here and see if we can have sounds like there's room for negotiation to get this done. If you can do that, then we can finalize things at that next date. If not, then we'll have to figure out how we go forward from there. So the court will
Thank you
send
so
out.
much, Your Honor.
Yeah, the court will send out notice of the date and time of that next hearing, and then, we'll go from there. Mr. Vernon, anything further from your side?
No,
Okay. Thank you. All parties on this case are free to disconnect at this time.
thank you.
Thank you, sir.
Huh?
Do you have an extra one?
Of course I do.
Sorry.
You worked with me for how many years?
Never want to assume.
I think it's funny though when some of the people out here and I'll just be writing and then you're like, I need a pen. I just hand you mine and then pick up the next one. And you're just like, wow.
That's what throws me off. That's the only one that you have that I'm taking it from you. Or,
No. No, I always bring two. Once a Girl Scout, always a Girl Scout.
All right, Mr. Fridline, I just need you to unmute, please.
Yes. Can you hear me?
I can, thank you. All right, we're on the record in People versus Zachary Fridline, case number 1293420. The record should reflect Mr. Fridline is present today by video. We also have Ms. Koch on behalf of the people present by video. Mr. Fridline, this is your petition to have a conviction from back in 2012 set aside. Ms. Koch, have you had an opportunity to review his petition and the other documents supporting that?
Yes, I received a letter from the Attorney General as well, who we're sitting here on behalf of, and he indicates he is eligible so long as the court finds that he has met the statutory requirements.
Do you have any objection with regard to the technical requirements?
I do not.
Okay, so Mr. Fridline, there's two other criteria that have to be met. Number one, the court has to find that your behavior and circumstances since the conviction would warrant having it set aside, and that it would be in the public interest to have it set aside. So can you tell me, number one, what's been happening with you since the conviction was entered?
I soon as I got out, I did everything I was supposed to with Frank, my parole officer. Within a month, I had my license and a car. And another month after that, I had a whole rental and everything else. And my mother bought a business. I've been helping her with that as well over here in Higgins Lake. It's where I live now.
Okay, what kind of business is that?
It's Mel's Pine Pantry.
And what's your role in that?
I'm a cook and I supervise.
Okay. Are there any other community organizations or any volunteering? Is there any other activities that you're involved in at this time?
No, just been working more and more.
Okay, what about family circumstances?
Can you elaborate for me, please?
Are you married? Do you have kids? What's going on?
No, I just bought a ring. I'm about to marry my girlfriend actually within the summer. She's in the military and we're going to try to start and everything else. That's why I put this in so I can make a better income so we can start a family.
Okay, is this conviction preventing you from getting a better job or earning more income?
Yes. I applied for a few jobs, FedEx be one of them. I have the number. His name is Joe Young. Or Josh Young, sorry about that. He owns the whole business. And he told me he can't hire me because of the fact of this crime. But he's been waiting for about 4 months ever since I put the petition in to hire me in. Also, my girlfriend's mom owns or manages the generation station there in Grayling. And she said if I have my conviction set aside, I can get into there. So it has been hindering me for a long time.
All right, and then why would it be in the public interest for the court to set this aside?
The public interest? To be honest, I wouldn't know what the interest would be. Like, I don't know. I have Asperger's as well, so I don't know how to answer that one correctly.
Yeah.
All I've been doing. Sorry.
Mr. Freeland, do you think that it would help the society if you were able to continue advancing your career and working in these positions?
Yes.
And these employers, they want you to be able to work in their positions, but you aren't able to because these crimes or this conviction is hindering you. Is that correct?
Yes.
And you think that being able to work would help your family and these employers as well?
Yes.
Thank you.
You're welcome. And for the record, the guy, Josh Young, that owns the FedEx company is a third party. That's what FedEx is, same as Amazon. He told me he will do anything in his power. He said he will fire somebody to get me in. And that's about $800 a week starting out. And it's not bad to start off since I have this crime. I've been hindered from getting apartments. I've been hindered to get housing. I'm just lucky I got this house for right now.
All right, thank you. Ms. Koch, do the people take any position as to whether the court should grant the petition?
I think the court should grant the position. I think he's met his statutory requirement.
Okay, thank you. The court finds that all the statutory requirements have been met to have the conviction set aside. In listening to Mr. Fridline here today, it's apparent that he's moved on from this prior crime, which occurred over 10 years ago now, and that he hasn't had any other issues regarding remaining crime-free and being a productive member of the community. The court also finds that based on his desire to gain better and more profitable employment, that it would be in the public interest to allow him to do that. So the court will grant the petition and the court will set aside the conviction. The court will enter an order reflecting that. And Mr. Fridline, if you need a copy of that, you can contact the clerk's office here in Grayling. It won't be available yet today because I have to do that order, but anytime after tomorrow, that should be available for your records.
Okay, I also have a few more questions.
Sure.
State police, I did the iChat. It only had the home invasion first degree. Then they sent me another paperwork in the mail that has other ones on it. I don't understand that. I searched everywhere far and wide to find all the crimes to put on that paper that you see in front of you. All the one I found was the home invasion first. But the ones they sent me had my other two that I had. The same home invasion second, larceny on motor vehicle, which are part of the same cases. The case number, I guess you want to call it.
So those underneath them in the judicial segment say nolli prosequi. That means that they are not convictions. They
Okay,
were,
I just wanted to make sure.
Yep.
Okay, and my other question for everyone in the court is, am I all set?
I would wait 6 weeks and check iChat. It takes a little while for them to process it. Ms. Medler processes them very quickly, but it takes the state police a little while to do it. So I usually recommend before you apply for a job that you run the iChat. It costs $10. But that's usually what the employer's running it. Make sure it's off there.
Okay, and thank you so much. It's been a long time for this.
All right, you're welcome and good luck to you going forward, Mr. Fredline.
Thank you, Mertz. Can I leave or you want me to stay?
When was it that we moved to 345?
That would be Sensky. Was it Sensky?
Oh, yeah, the 315.
Yes.
Okay.
Yeah. Can figure it out.
Ms. Bailey, quick, which case are you signing in on?
The Creps matter?
Oh, okay. I didn't see you on that one. Is Mr. Blumberg your opposing counsel there?
He is. I haven't filed an appearance yet because I've been having difficulty reaching my client, so I was hoping he was appearing.
He called me yesterday. I think it was yesterday. I gave him the Zoom information because he said he would be calling in today.
Let me see if this is. Got somebody joining by phone here. So you're going to need to connect the audio on your Zoom app. All right, can you
Hello?
tell me your name?
Robert
your name.
Creps. Robert Creps.
Ms. Bailey, quick, I don't see Mr. Blumberg on yet. Did you want a breakout room with your client?
Sure.
Okay, I'll put you into a breakout room. If you can keep it to 5 minutes or less, please. Just a minute, I'm just having a little technical trouble here. Okay, here we go. Mr. Creps, there should be a notification there asking you to join the breakout room.
Oh, okay. Yep. All right. I hit it.
Yeah, each one. Each one's good.
I'm gonna say it's them all.
Ms. Creps, are you able to hear me okay?
Yes, I am.
Are you still represented by Mr. Blumberg?
I am.
Okay. Have you talked to him about today's hearing? It was set to start at 2 and I don't see him in the waiting room, and Mr. Blumberg is usually not late.
Yeah, he said something about it could be 2 or 2:15 because there was another appointment at 2. But I don't know. I talked to him last night.
Okay, so I'm just gonna ask you I'm gonna put you back just in the waiting room, and then when I see Mr. Blumberg, I'll bring you back in on the other side as well, okay?
Okay, thank you.
Thank you.
That's the last one of it. Then you got all the things.
See in there?
Okay, looks like we've got everybody starting to join in here. I think we have everybody. Okay, so let's go on the record in Creps versus Creps. This is case number 2311452. Both parties are present by Zoom video. If I could have both counsel put your appearances on, starting with plaintiff.
Judge, he's unrepresented.
Ms. Bailey Quick apparently has just made an appearance on his behalf.
Oh, nice to know. Thanks for the heads up.
Ms.
Your
Bailey
Honor,
Quick,
Miranda
your
Bailey
appearance on?
Quick. I'm just gonna watch at this point. I guess my client has reached a resolution with his wife.
Okay, so are you not making an appearance then?
I am not gonna make an appearance.
Okay, Mr. Blumberg, you're present on behalf of Ms. Creps, correct?
Yes, Judge. And again, I was led to believe that the parties had come to an agreement. And based on that agreement, we drafted a proposed judgment of divorce, which I believe Mr. Creps came into my office today and signed. So I think all of the issues have been resolved, at least as far as I can tell.
Yes.
Mr.
Yes.
Creps is, okay, good. All right, so Mr. Blumberg, did you want to take some proofs from your client then?
Well, Mr. Creps is the plaintiff and there's been no counter complaint filed. Can I ask him these questions or however you want to do it?
Why don't I start out and then let's see where we go from there. So, Mr. and Ms. Creps, can you both raise your right hands, please? Do you both solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
All right, thank you. If you could lower your hands. Mr. Creps, you filed a complaint for divorce in this case and you signed that complaint. Is that true?
True.
At the time you signed that complaint, had you been a resident of the state of Michigan for at least 180 days?
Yes.
Had you been a resident of Crawford County for at least 10 days?
Yes.
In that complaint, there's a statement that indicates that there's been a breakdown of the marriage relationship such that the objects of matrimony have been destroyed and there remained no reasonable likelihood that the marriage could be preserved. Was that true when you signed that complaint?
True.
Does that remain true today?
Yes.
Are there any children under the age of 18 that were born to or adopted by you during the marriage?
No.
Are you going to be receiving any alimony or spousal support as part of this divorce?
No.
You understand that you would be waiving that forever and that you would not be able to come back later and ask the court for that?
Yes.
All right, thank you. Ms. Creps, have you heard all the questions that I asked Mr. Creps?
Yes, I have.
Have you heard all of his answers?
Yes, I have.
Do you have any reason to believe that any of the answers he gave were untrue?
No.
Are you currently pregnant?
No.
Okay. All right, Mr. Blumberg, I think I've covered the bare statutory grounds. Were there any other questions that you wanted to ask of either party?
Yes, Judge. Now, let me start off with my client, if I might. Ms. Creps, you and your husband have come to an agreement as to the issues of spousal support. Is that correct?
Correct.
And that commencing on April 1st of this year and continuing for the next 36 months, he will be paying you spousal support in this matter. Is that correct?
Correct.
And the amount of that support is how much?
$400 a month.
Okay, and that is non-modifiable support, meaning neither you nor he are going to come into court or going to be able to come into court and to seek to modify that, meaning you can't come in and ask for more, nor can he come in and ask that that be reduced. Do you understand that?
Yes.
And is that your agreement?
Yes.
You've also agreed, as I understand it, that he is going to continue to pay your car insurance on the Jeep currently owned by you. Is that correct?
Correct.
Okay, and those insurance payments are going to continue so long as you own that vehicle. Is that right?
Correct. Correct.
You've also agreed that he's going to pay you the sum of $2,000 in exchange for the 2010 Ranger side-by-side. Is that your understanding?
That is correct.
And the judgment provides that that payment is to be made within 21 days of the entry of the judgment. Is that your agreement?
Yes.
You guys have already sold the home that you own together and divided those proceeds. Is that your understanding?
Yes, we have.
And to the extent that either one of you have any kind of retirement benefits or pensions, each of you are going to keep your own and waive any claim you may have to the others. Is that your understanding?
That is correct.
And again, in terms of attorney's fees in this case, you are going to be responsible for your fees. Is that correct?
That is correct.
This agreement that you and Mr. Creps have come to, do you believe that to be both fair and equitable?
Yes.
And are you asking the court to adopt this and ultimately sign the consent judgment of divorce?
Yes.
Okay. Thank you. Your Honor, I have no other questions.
Okay. Mr. Creps, if you can turn your microphone back on. Looks like we lost Mr. Creps for a moment there. Mr. Blumberg, if you and Ms. Creps can just hold on for a minute, we'll see if he reconnects.
Sure.
Hello?
Yes, Mr. Creps, are you there?
Yeah, I'm here.
Okay, were you able to hear all those questions that Mr. Blumberg asked of Ms. Creps?
Yes.
Do you agree to all those terms, as he indicated?
Yes, I do.
Okay. All right, the court finds that the statutory grounds for divorce have been met by the testimony of both parties. The court finds both parties have indicated assent to the terms of the agreement for the judgment as indicated by Mr. Blumberg. So the court will grant the divorce. Mr. Blumberg, will you be submitting a copy of that judgment to the court for signing?
Absolutely, Judge, we sure will.
Okay, Mr. Creps, did you have any questions at all?
Yeah,
Can you repeat that? You were breaking up.
is what I'm thinking. Or not? Are we done?
So, Mr. Creps, I only heard the very end of what you said. We're breaking up there. Can you repeat what you just said?
I said, is this our final appearance or do we got to come back for another one?
No, this is it. Mr. Blumberg is going to submit that judgment to me. And then once I've signed that, it'll be final, but you don't have any further proceedings to attend.
All right.
Okay, thank you. That's all for today. All parties on this case are free to disconnect at this time.
Thank you.
Thank you.
Thank you.
Was it Sensy that moved? Yeah. Okay.
Full coverage on it.
All right, Mr. Vernon, are you able to hear me okay?
I can hear you. I want to make sure that. All right, can you hear me?
Yes, you're coming good through very good now. Mr. Sarah, are you able to hear me?
Yes, I am.
Okay, and Mr. Sarah, are you still represented by Mr. Cutler? You're muted there.
Yes, I am.
Okay, is he aware of today's hearing? Have you talked to him about today's hearing?
He sent me an email a couple of weeks ago regarding it, so he does know that it's going to occur. I can give him a phone call.
Okay, yeah, if you want to do that, and Mr. Vernon, if you and your client can just hold on for a minute, we'll see if Mr. Cutler joins in here.
Judge, I don't want to rush anybody, but I do have a 2:30 phone call with Judge Burmeister regarding a family court matter.
Yep, I understand. We'll do what we can.
Yeah. Oh, she didn't give me that phone. Oh. Mr. Sarah, you're muted too. I don't know if the judge was muting us all.
Mr. Sarah.
Hmm.
Mr. Sarah.
Yeah, he's joining.
Oh.
All right, we have Mr. Cutler connected. We'll go on the record. This is Sarah versus Sarah, case number 2311355. If I could have both counsel put your appearances on, starting with plaintiff.
I'm Vernon on behalf of Jody Sarah, who's present in my conference room. We are appearing remote.
Afternoon, Your Honor. Michael Cutler on behalf of the defendant, Stephen Sarah, who is on screen. I apologize, Your Honor. I had this down at 2:30. Maybe I was mistaken.
Okay, no problem. We're on the record here today. I believe, Mr. Vernon, this is your motion for attorney fees. So how did you want to proceed?
So my staff's conversation with your staff identified this as not necessarily an evidentiary hearing, but a scheduling hearing. I don't know that Mr. Cutler and Mr. Sarah or ours or me and my client are necessarily prepared at this point. We had just prepared and sent over to Mr. Cutler the answer to defendant's first set of interrogatories request for productive documents. So I'm not sure that he's even received those yet, but I think in order to conduct this hearing on income and finances and ability to pay, I think both parties would need to have access to that information and be ready to proceed. So my understanding was we were simply gonna have a 15-minute essentially pre-trial type of hearing to determine if we were going to have an evidentiary hearing, and if so, how long the court should set for it.
Okay, how much time do you want, Mr. Vernon?
I think an hour. I think it's gonna be two witnesses. I think it'll be just the parties and questions about their income.
All right, Mr. Cutler, all right, Mr. Cutler, do you believe that would be a sufficient amount of time to set aside for a motion hearing?
I would hope that an hour would be sufficient. I know I directed both informally and I believe also formally interrogatories and request for reductions to opposing counsel. So I would like to receive those. I know I received his first set of interrogatories about 2 weeks ago or so. So I do need time if we haven't provided them already, which we may have, we might need some additional time. I do have one conflict, Your Honor, because I thought this was the date and time for the motion itself, as opposed to the actual request for an evidentiary hearing. So I thought this was going to be a two-stage process. First, to determine whether or not there's even a basis to proceed for a request for attorney fees, and if so, to have an evidentiary hearing. My issue is I'm leaving the country on Monday, the 11th. I don't know about the court schedule, but I do not return until 3 weeks thereafter, April 2nd.
Okay, that should not be a problem because I won't be able to set up for hearing before that. So that would not be a problem. In fact, yeah, that won't be. So the court will put this on for a 1 hour evidentiary hearing. The other question is typically I've been scheduling for the updated court rules on video conferencing. I've been scheduling evidentiary hearings, which this would be in person, unless the parties stipulate to have it remotely. The counsel, either, do you have a preference? Do you want to stipulate to having it remotely? If not, or if we don't have agreement, then the court would simply set it for in person.
I would request to be remotely. If counsel doesn't agree, of course, I'll be there in person like I was last hearing. But I'd like to try to keep the cost to the marital estate as low as possible. And I want to try to avoid the additional expense of the travel.
Mr. Vernon?
I have no objection. I prefer to do it in person, but he's coming from Farmington Hills. I have no objection to doing it remotely. And we actually have a mediation, I think, scheduled coming up, so maybe we can resolve the whole thing then and not need that hearing.
Okay, that would be obviously the best outcome, I think. So the court will set this for a hearing, 1 hour evidentiary hearing. The court will set it remotely by stipulation of the parties. The court will send out notice of the date and time of that hearing. And Mr. Cutler, again, I don't think it'll be an issue, but I will let my assistant Jennifer know not to schedule it during the time that you'll be out of the country or immediately after, to give you an opportunity to be prepared for the hearing. And then we'll go forward from there. Mr. Vernon, anything else we can address for your side today?
No, no.
Mr. Cutler?
No, thank you to the court for the consideration. And we do have the mediation on Monday at 10:30, so hopefully we'll be able to reach a resolution. If so, we'll certainly contact Chambers right away.
Okay, sounds good. Thank you. That's all for today. All parties are free to disconnect at this time.
Thank you.
Thank you, Mr. Cutler.
learning how to make homemade bread and pasta.
Cool. Yeah, that could be dangerous.
Yes. Yes. Yes.
All right, looks like we have both council connected, so we'll go on the record in Laddock versus Bradshire. This is case number 2311388. If I could have both council put your appearances on, starting with plaintiff, please.
Good afternoon, Judge Daniel Randazzo on behalf of the plaintiff.
Julie Frischman appearing on behalf of the defendant.
Thank you. We're on the record here today for hearing on 2 defense motions related to discovery. I did receive both motions and briefs, had a chance to review those as well as plaintiff's response. Ms. Frischman, any argument in support of your motions here today?
Well, seeing as you have read everything, it seems to me that you've got a good grip on the issues. I would only like to add a couple of supplementary points, starting with the motion to compel. You've already read the response, and I recognize Mr. Randazzo is saying to you, Judge, I don't have a statement, but 2 things, if I could reply to that. These, of course, were interrogatories identifying just 3 people, and of the 3 people, I asked, what do they know and what will they say? 2 things. First, remember the interrogatories are directed to a party. It's not the attorney; it's a party. And considering the fact that this was a gathering of people known to the plaintiff, when I identify 3 of the people at his party and ask, what do they know and what will they say? The plaintiff has to know. And the more egregious the plaintiff paints the circumstances of this case, there's even more of a reason for plaintiff to know what everybody saw and what they're going to, share if they come to the trial of this case. So the point I make is, it's not what the lawyer knows, it's what the party knows. And he's the one who signed off on the answers. The other comment on that is the mere answer that we have, which is they'll testify about what they saw and what they did, is a pretty clear indication that these 3 people did see something. There's nothing indicating that they weren't in the room. And there is, to my knowledge, there was one individual at this party who was in the cabin, didn't see anything. For all we know, these 3 were equally in the cabin. So there seems to be a suggestion, if I can read between the lines, that perhaps there's information out there. I leave that as my 2 rebuttal points on that one. The other point I would add, which wasn't in the briefs with respect to the motion on the authorizations, to the extent that plaintiff goes to trial with me on this case, and he testifies that the incident has given him headaches and problems, which I think he might, I am entitled to know his medical condition. He's clearly put it in evidence. This is a personal injury case. But more importantly, the injury that we learned he sustained, that he didn't share with us, by the way, I had to find that by reading a record. It was a head injury. And not only has he put his physical condition and mental condition to evidence, but all of that could be relevant here as to what he may claim as damages. So without question, Your Honor, I think I'm entitled to, at the very least, receive this information, at the most use this information if needed. And if plaintiff's counsel doesn't like it, let him proceed with a motion in limine down the line. Those would be the only supplementary points.
All right, thank you. Mr. Randazzo?
Judge, just real briefly, you read my response. I mean, the authorizations came in after discovery was closed. The information relative to a concussion that he suffered months after the injuries that he suffered, burns to his legs. The defendant took the plaintiff's deposition, and in that he testified that he suffers from PTSD. He didn't talk about any headaches or anything of that nature. As with respect to the issues regarding the responses to the interrogatories, they weren't my responses. They were written as plaintiffs. He hasn't talk to these people, other than his two siblings. He doesn't know what they saw or what they heard, or what they would testify to at trial. And as I indicated, defendant, if they wanted to know what those people were going to say, they could have deposed them, and they did not. It's not my obligation to necessarily tell them what some witness may have seen or not seen. So with that, I'm asking the court to deny both motions.
Thank you. Mr. Firstman, they're your motions. Anything that you wanted to say in response?
You've read them, and to address the timeliness issue that was raised by Mr. Randazzo, as the motion states, we sought medical records before the discovery cutoff. In fact, I think it was the beginning of the month. It was beyond our control, Your Honor, for the service that we used to delay in sending the authorizations to opposing counsel, in this case, Mr. Randazzo. So if the timeline of the discovery cutoff is a critical point for your evaluation, I just want to reaffirm, we did seek that information timely. It was what happened afterward. But I would override that anyway with the fact that we were asking plaintiff to share information and updates on his health and who he's treating with, and we never got it. It was through our own effort that we found that information on our own before the close of discovery. Finally, with respect to the motion to compel more complete answers to interrogatories, I understand the point that Mr. Randazzo makes, which is, oh, well, my client doesn't know. That to me seems disingenuous under the circumstances of this case. And the point of, well, we could have taken the depositions of all these people. That's true. There were many, many people in attendance at this event. Could we have done that? I suppose it would have been an effort. It would have been an expense. We would have had to subpoena a number of kids who are all over the place this time of the year. I leave with you, Your Honor, my request with respect to the motion to compel, that I would ask Your Honor to issue an order advising plaintiff that if he knows information about what each individual, just those three, saw at the event and what they may testify about, I would ask that we have plaintiff be ordered to produce it. And if his answer after an order of the court is, I've never spoken with them, I don't know anything, I guess I would have to live with that because it's an order. The point I make is I want to avoid trial by ambush, where I get these answers that are non-answers, and then suddenly a massive amount of information comes forth at trial. That's all I wanted to offer.
All right, thank you. Again, I did have a chance to review the motions and the responses, taking all that information into account along with the arguments of counsel here today. First, with regard to the medical authorizations, given the claims in this case, plaintiff's allegations, given the potential that those records may be relevant, I do think the defendants are entitled to review those records. So, and I'm talking specifically about the December 2023 and early January 2024 medical treatment with McLaren McComb and Dr. Alex Steinbach, DO. So I think defendants are entitled to review those because I think they may contain, or there's a reasonable likelihood that they will contain evidence that's relevant to the case. So the court will grant the motion as it relates to authorizations for those specific records. With regard to the interrogatories, I guess there were a lot of witnesses that defendants could have chosen to depose, or all of them. For whatever reason, the defendants chose to single out these three individuals in particular. They could have chosen to depose those three people. I don't think the plaintiff is required, either through counsel or the plaintiff himself is required to go to these people when they receive an interrogatory and investigate and find out what those witnesses know so they can answer the questions. Either the plaintiff knows or they don't, and either those people have given statements to the plaintiff either voluntarily or at the plaintiff's request, or they haven't, and the answers are what they are. I get this a lot where a party sends out interrogatories and doesn't necessarily believe the answers they're getting, and then files a motion to compel, saying, just what you said, Ms. Firstman, like, I just don't believe it. I think the plaintiff must know. Unfortunately, we're all stuck with the answers that are given to signed interrogatories, and the plaintiffs indicated that they don't know. I don't think, again, the plaintiff's required to find out. And I think the defense, it's up to the defense to depose people if they want to find out specific information or find out information that's not within the knowledge of the plaintiff. And I don't find it to be particularly surprising, you know, the plaintiff doesn't know exactly what these people saw and what they might say. And if the plaintiff hasn't specifically looked into that and doesn't have that information, they're not required to do that to be able to answer discovery. So I will say that, you know, I think the motion has merit though, and I think if the defendants, and I certainly think those witnesses may have relevant information if they were eyewitnesses to the incident. And so I would, upon request, if the plaintiff's going to object, I would grant the defendants leave if they want to subpoena those individuals and depose them. I think that would be appropriate, but I don't think the onus is on the plaintiff to go get that information. I think the plaintiff has provided answers to the interrogatories, which are, we don't have statements and we don't know what they're going to say. And they are stuck with those answers just as much as the defendant is. So the court is going to deny the motion to compel the plaintiff to do anything with regard to those interrogatories.
Your Honor, may I interrupt for a moment? You did mention that you would grant leave to subpoena the 3 individuals. I would accept that if that's acceptable to you as the order on the motion, and I'll proceed with their depositions. We can put a timeline as to when they need to be completed by, if you'd like.
Sure. What kind of timeline are you looking at?
How about in the next, well, let's see, we are at March. These are kids who are college age. I have no idea how things work on that, but I'm thinking if we could do it in the next 5 weeks, just to make sure we cover any conflicts at their end.
All right, Mr. Randazzo, I know you may not necessarily want to stipulate to that, but is there any record that you want to make or objection that you'd like to make a record of on that?
Yeah, Judge, other than, you know, the timeliness of it, you know, she wants to subpoena them and take a deposition. I'm not opposed to it.
Okay, so the court will grant 60 days and the discovery would be limited only to deposition of those particular witnesses. In other words, the court's just not generally reopening discovery. So Ms. Firstman, if you can include that in your order. And then I was going to ask you to prepare an order anyway on the other motion and submit that under the 7-day rule. Ms. Firstman, anything further from your side today?
Nothing further. Thank you.
Mr. Randazzo?
Yeah, Judge, I just want to alert you to the fact that you ordered facilitation in this case. We attempted facilitation a couple weeks ago. It lasted 10 minutes. I don't think the defendant came to that process in good faith. The facilitator indicated that they were not willing to come bump with any kind of a counteroffer or anything, and it ended in 10 minutes. And I don't think it was in good faith. So I think court should order new facilitation at some point, and I don't object to the court picking a facilitator, but I think you got to advise the defendant that they got to act in good faith.
Ms. Firstman, what's your response to that?
Well, my response is multifaceted. I'll try to keep it short. I've been practicing law for almost 38 years, and I've never had a mediation this short in my life. And the reason is, there's a jury, so you can be told this. The demand that we received at the beginning of this mediation was far in excess of anything I or the claim rep I'm working with ever expected in this case. So in discussion we had with the mediator and the options that we ran by the mediator, we all concluded, and the mediator did not object, that this mediation was going to go nowhere because the demand was 7 figures, and we didn't think, in fact, almost double 7 figures. We didn't think the case had anything near that. And if we responded to try to get things moving, we thought they would walk out right away. So this wasn't just us leaving the mediation. It was us conversing with the mediator, who was supportive of what we did.
All right, Mr. Randazzo?
That's not what I heard from the facilitator. It's his comment to me was that they're unwilling to present any kind of a counteroffer. It doesn't matter whether I gave a number that they didn't expect. They didn't even try to give me a different number, and I don't think they came to that process in good faith. So I think the court should order a new facilitation and order them to participate.
Well, let me ask you this, both counsel. I mean, you're both telling me here, Mr. Randazzo, you're saying that defendants didn't come into this with good faith because they didn't provide any kind of counteroffer. Ms. Firschman's telling me that plaintiff's initial offer was so far in excess of what would be considered a fair offer that essentially the plaintiffs didn't come into this in good faith. So what am I supposed to do with that? You're both accusing the other of the same exact thing. I don't know what the offers were either way. So what do you guys want me to do with that? Am I supposed to believe one of you over the other one?
No, I think we should just order a new facilitation.
Well, what good is that going to do if you're going to come with the same initial offer and they're going to have the same position? I mean, where's that going to get us?
Probably nowhere.
Okay, so that again, I asked, what do you want me to do here realistically?
Well, I think and I've been practicing almost 38 years, and in every facilitation or mediation I've been in, there has been, regardless of the opening offer, there has been some kind of a response. And to come back and for the facilitator to say that they're not interested in doing anything, even to say to me, your number's too high, give me a different number and I'll go back. That never happened because he knew that they were not going to come up with any kind of a number.
All right, well, I mean, where I'm at with this is I ordered mediation. You guys are either going to both come to it reasonably and participate in it, or you're not. And I can't tell sitting here which one of you did and which one of you didn't.
Well, I can put it this way. If Dan wants to mediate again, sure.
You guys are free to agree on mediation if you want to do it again. Otherwise, we'll just go to trial. I'll set some time aside and you guys can present your numbers to the jury and the jury will decide which one of you is closer to what's realistic and what's not. So that's where I'm at. I'm not going to babysit you guys through the mediation process.
Very good, Judge.
If you both want to participate in it meaningfully and settle the case, you're free to set it up again on your own.
Okay.
Dan, you know where I stand. You're welcome to give me a call. You may not like what we offer, but we can talk.
Okay. Appreciate it.
That's all for today. All parties are free to disconnect at this time.
Thank you.
Thank you, Judge. Have a good day.
Thank you.
Thank you, Julie.
I didn't know your job was that hard.
All right, looks like we got the parties present. We'll go on the record in Sensy versus Bulky, case number 2311454. If I could have both counsel put your appearances on, please.
Thank you, Your Honor. Jason, plaintiff, Jack Sensky.
Afternoon again, Judge Elliott Blumberg on behalf of the defendant who is appearing via Zoom from my office.
Okay, thank you. We're on the record here today for a status conference on behalf of the plaintiff, Mr. Thompson. Can you tell me where things are at this point?
Yes, Your Honor. The parties have reached an agreement after the judge have sent it over to the defendant. I believe it's in an acceptable. Our intentional proofs on and have that submitted, Your Honor, for signature.
All right, thank you, Mr. Blumberg.
Judge, that's correct. There were some slight revisions that we requested. Mr. Belke and I have agreed to the terms of the proposed judgment. So I guess it would be appropriate if the court would allow the plaintiff to take the proofs. You should have a signed judgment before you fairly soon.
Okay, thank you. Mr. Thompson, if you could have your client on the screen there. Ma'am, can you raise your right hand, please? You solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you. You can lower your hand. Mr. Thompson, your microphone is cutting in and out a little bit. I don't know if that has to do with where it's located, but the audio isn't super clear. So if you can just speak slowly, and then Ms. Sensy, as you answer the questions, if you can speak slowly as well. And go ahead, Mr. Thompson.
Thank you, Honor. Thank you, Honor. Are you Jacqueline?
Yes, I.
And did you obtain me to file a complaint for divorce in this case?
Yes, I did.
And at the time that complaint was filed, it is true that you had resided in the petition 108.
That is correct.
And you had resided in Crawford for at least 10 days.
That is correct.
All right. And defendant during. Correct.
That is correct.
All right. You were
Mr. Thompson, I'm sorry to interrupt, but I'm only getting like every other syllable of the words that you're saying, so I'm worried we're not making a clear record here.
Your Honor, if you could give me a minute, retire to a different device.
Okay, thank you.
I know. Yeah, no, they're in his office.
All right. Is that better, Your Honor?
Yes, that's much better. So maybe can you just start right at the beginning of your questions, please?
Certainly. Are you Jacqueline Sensky?
Yes, I am.
All right. And did you cause my office to file a divorce complaint in this case?
Yes, I did.
All right. And at the time that complaint was filed, it's true that you had resided in the state of Michigan for at least 180 days?
That's correct.
And you had resided in the state of Michigan for at least 10 days?
That's correct.
All right. And those statements are also true of the defendant, Mr. Bulkey?
That's correct.
Okay. And you were married to the defendant, Mr. Bulkey, is that correct?
That's correct.
All right. And I believe that was August 18th of 2018?
Correct.
All right. And ma'am, we have to ask everybody, were there any children of the marriage?
No,
And are you currently pregnant?
no, I'm not.
Okay. And you have agreed to a proposed property division that would dispose of any jointly owned assets or debts of the marriage. Is that correct?
That's correct.
All right, and that's that document you signed in my office today?
That's correct.
All right, and you're asking that when that's submitted to the court, that that be accepted as the final judgment in this case?
That's correct.
All right. Has there been a breakdown of the marriage relationship to the extent that the objects of matrimony have been destroyed?
Yes, that's correct.
All right, and is there a reasonable likelihood that the marriage can be preserved?
No,
Okay, and are you asking the court to enter a legal divorce in this case?
yes, I am.
All right, and there's no need to address a name change because you didn't change your name upon the marriage, correct?
That's correct.
All right, I don't have any further questions, Your Honor. Thank you.
Mr. Blumberg, did you have any questions of Ms. Sensky?
I do, Judge, just a couple. Ma'am, you and your husband have come to an agreement on the division of the marital asset. Is that correct?
That's correct.
And you have separate property that you own prior to the marriage, as does your husband. Is that correct?
That's correct.
Okay, and each of you are keeping your separate property. Is that your understanding?
That is correct.
During the course of the marriage, you and your husband did acquire another parcel of property that he is being awarded. Is that your understanding as well?
That's correct.
And in exchange for that, you are to receive the sum of $35,000. Is that correct?
Correct.
And that is to be paid within 30 days of the entry of the judgment of divorce?
That's my understanding, yes.
Okay. And again, as to the ultimate division of the marital estate, you believe it to be both fair and equitable?
Yes.
And neither one of you are seeking spousal support, and neither one of you are going to be able to come back before the court at a later date. Do you understand that?
Yep, that's correct.
Okay, great. Thank you. I have no other questions, Judge.
Thank you. Mr. Blumberg, did you want to take any testimony of your client today?
Yeah, just briefly, if we could.
Mr. Bulkey, if you could raise your right hand, please. Do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth to help you God?
Yes, I do.
Thank you. Go ahead, Mr. Blumberg.
Mr. Bulkey, just a few questions. First of all, you heard the questions I asked of your wife. Do you believe her answers to be fair and accurate? Yes, I do. And the agreement that both of you came to are reflected by her testimony. That is, you're keeping the property that you had prior to marriage, and she is keeping her separate property.
Yes, that is correct.
And you've agreed that the property that you acquired together with her, you're going to be you're retaining that, and she will be signing a deed over to you.
That's my understanding, yes.
Okay, and in consideration of that, you're going to be paying her the sum of $35,000.
Yes,
And you've agreed to make the payment within 30 days of the entry of the judgment, correct? And again, you understand that neither you nor she is seeking spousal support, and neither one of you can come back at a later date and ask for that.
that's correct.
Okay, thank you. Judge, I have no other questions.
Mr. Thompson, did you have any questions for Mr. Bulkey?
No, Your Honor. Thank you.
All right, thank you. The court finds that the statutory grounds for divorce have been met by the testimony of both parties. The court will grant the divorce. Once the judgment of divorce is submitted, the court will sign that. Mr. Thompson, anything further that we need to address for your side today?
Nothing further. Thank you.
Mr. Blumberg?
No, Judge, thank you.
Okay. All right, thank you. That's all for this hearing today, and all parties are free to disconnect at this time.
trying to get rowdy? Because this is my turn today.
All right, let's go on the record. Oh, all right, Ms. Koch, are you able to hear me okay?
Yes, Your Honor.
Okay, we're on the record now in two matters. People versus Arthur Gahn. This is case number 235160. And Grgoski versus Gahn, case number 2311370. The record should reflect Mr. Gahn's present here in the courtroom today. Also present on his behalf in place of Mr. Germerthy is Mr. Jaskowski. And Mr. Gahn, do you have any objection to Mr. Jaskowski appearing for you today?
Who? Oh,
Me.
Yeah, sorry, no.
Okay.
No problem.
And we have Ms. Koch present on behalf of the people. Really with regard to both matters, I think. Maybe not. I can't remember if she was involved in the PO matter. Actually, I don't think so. So just as to the criminal case then. This is a hearing that was set today for the purpose of monitoring payments. Ms. Koch, do the people have any position on this right now?
We do not, Your Honor.
Okay. And what I'm asking the clerk to go on the record here with just an accounting for me so that I know what's happened, and what has not happened.
Dylan, did you bring in that email?
Yes, I did.
Just, if I can refer to this, Mr. Germerthy asked me to send an accounting. So on the PPO case, he made a $15 payment on 2/6 and a $15 payment on 3/4. On the felony case, he paid $15 on 12/4, $20 on 1/5, $15 on 2/6, and $15 on 3/4.
Okay. All right, Ms. Koch, with that information, is there anything further that you wanted to add today?
No, Your Honor.
Mr. Jaskowski.
Your Honor, I just note that, it seems like Mr. Gahn is doing what he can to make payments every single month. It seems like, almost to the day, the 4th, 5th, 6th every month, every time he gets disposable income, he's coming to the court with those funds to make payments. I'm sure you can
Well, I gave my word, I would.
I'm sure you can see as well that he's physically unable to work and he is on a fixed income.
Okay. All right, Mr. Gahn, it does appear that you've been making efforts towards paying off the fines and costs as to both files, so the court's not going to take any further action at this time.
All right.
The court is going to set this for another review hearing about 6 months out. So
Okay.
I wanted to set this one close in time to monitor this and keep an eye on it. Because you are making payments, we're not going to set any further hearings for a bit here yet to continue to monitor. But it is important that you continue to make those payments as you can.
I'll give you my word, I will, Your Honor.
Okay, thank you. So that's all for today. Ms. Koch, I do want to make the record though, the court did receive a communication from Mr. Grgoski, who's the victim in your criminal case. And he's not entirely satisfied with the restitution payments. I think that's something, and I'm letting you know that as a courtesy. I don't know if you got that letter or not. I can certainly forward that to your victim's advocate if she wants to make contact with Mr. Grgoski regarding the restitution in the criminal case. You're muted, Ms. Koch.
Thank you. I did not get a copy of that letter. We would like to have a copy. Thank you.
Okay, I'll forward that to you. That's all for today.
Can I say something, Judge? Just because it's on my mind, and I want to, let you know before the next court date, so you keep something fresh. Some things have come to light, and I'm hoping the prosecutor's listening. She knows about the other cases. Some light has came on to me within the last couple of days. My teenager, my oldest one, been having trouble with him for the last 2 years. I came to you and got custody from when the boys were 10 and 12. They're now 13 and 16 for pea and vinegar. The 16-year-old's giving me a run for my money. He's on probation. I just signed him up for boot camp. During the middle of all this is when the tractor issue come up. None of my guns were fired. I'm still.
I don't know that we.
Well, just hold up.
Well, Tend to agree
The
with
only
you,
reason
Blair.
why I created a fiasco obviously, the last time we were here, and I wanted to make sure that you understood that the only reason why I asked to settle the other case was because I just wanted it over between me and Dragowski. I didn't want to argue with him anymore. I don't want to talk to him anymore. I could clearly stay out of his way. And it did not look like that last time I was here, and I apologize for that. I made an oops and created a fiasco, and I'm paying for that. And I want to make sure that you know that from here forward, I'm going to toe that line straight as an arrow. I'm not going to screw up. I'm not going to, do anything wrong. I've got a BB gun at home that the kids play with, and the BB gun was put away for the winter because you don't play with that during the winter. And I'm wondering if that's what got my ass in trouble.
I really don't know.
I mean, neither. So, but 2 and 2 make 4 to me. So, at any rate, I'd just like you to know that I want all this behind me. I don't want to keep this going. I'm tired of it. I just want to pay my dues and keep going my life.
So I think that's something that everybody involved from all sides can agree on. So let's keep it moving in that direction.
Yes, sir.
Thank you.
Thank you, Judge.
That's all for today, and all parties are free to disconnect. That also concludes the court's afternoon docket.